Good evening, everybody. Hello, YouTube and Facebook. I had to try to remember, okay, it's been a long day. And excuse my voice, just try to sound. I've had this cold, and you can't have a cold now. Everybody thinks it's COVID, right? I'm okay. Don't start no rumors. But hi, everyone. Happy Monday. Come on in, say hello. Let's have a very, very quick video and talk about a topic that's very, very important to a lot of, well, quite a number of my clients. When you come on, say hello. Let me know you're here. This is attorney Abisola Olaleye, immigration lawyer based in Alabama, representing immigration clients in all 50 states. Like I always say, if you've got an immigration case, if it's a case that my firm handles, we can and do represent immigration clients regardless of the state you live in. So, I'm gonna clear my throat. I've spoken for the whole day. I had a contested divorce trial, and that's why I have gray hair. That's why I have gray hair. Sometimes it's like, why in the world did I sign up for? But anyway, I do enjoy it. I do enjoy defending people. I really, really do. I really do. But hello, Shauna. How are you? But let's talk real quick because I'm in between consultations, and I said let me talk about this topic real quick because I know that, like I always say, if someone has that question and someone has that same issue, that someone else is dealing with that, and the question today is, or the topic today is, my Vawa abuser is a green card holder. Am I able to adjust my status in the country if my abusive spouse is a green card holder rather than a citizen? And the short answer to that is yes. And I'll tell you why. So, generally, if you need to contact our office, you can see the number, email, and contact number scrolling across the screen, 334-341-4475. Send an email to aos@olalayelawfirm.com. You can also visit our website. Let me put that back up real quick. That's 𝐸𝐸LawFirm.com. If you need to set up a consultation with us, consultation is $130 for half an hour and $230 for an hour. And if we're retained within 15 days from the consultation, you will get that amount credited towards your total legal fees. So, if your Vawa abuser is a green card holder, are you eligible to apply for and adjust status to that of permanent residency without having to leave the country? Short answer to that is yes. Generally, when you file, now there are some exceptions, just like everything, where I'm talking about someone who doesn't have any other inadmissibility issues besides unlawful presence and married and trying to get your green card while you're married to a green card holder and you've already accrued unlawful presence. So generally, if you are someone who has accrued unlawful presence and you're married to a green card holder, generally in a marriage base, you will not be eligible to apply for permanent residency in the country. You will have to wait until your spouse becomes a citizen. That makes you an immediate relative, and immediate relatives, whether or not they have overstayed, as long as they came in legally, unlawful presence is forgiven. It is not forgiven if your spouse is a green card holder because you're not an immediate relative. So you would generally have to wait until your spouse becomes a citizen, and then you're able to apply for your I-485 as an immediate relative. Or if your spouse has no plans of becoming a citizen, or your spouse is not eligible to become a citizen, then that means your only choice will be to apply for a waiver of the unlawful presence, which is a 601A. And once that's approved, you would have to go apply for your immigrant visa at the embassy. That's the general rule. Now, it is different if you are filing for VAWA. Unlike when you file and you're married to a citizen, and then you have to get the vow, or you have to get the waiver, or you have to wait until your spouse becomes a citizen. In a vow case, if your spouse is a green card holder, you're not required to leave the country in order for you to apply for your immigrant visa or to apply to register that permanent residency. Because in a vow case, that unlawful presence is not only waived for immediate relatives, it is also waived for the F2A preference category relatives. F2A category includes spouses of permanent residents. So unlike the regular marriage, that's one another benefit of, if you qualify for vow, obviously, that's going to be one of the benefits that you would have. That is, unlike in a regular marriage, which where you have to wait for your spouse to become a citizen, or you file a waiver for the unlawful presence, have that approved, then you have to go to an embassy. In a vow case, once you file, and right now the F2A category is current. Once you file, you're actually eligible to file your I-360 as well as your I-485 simultaneously, as long as that preference category is current. Whether or not you're accrued unlawful presence, and with the fact that your abusive spouse is a green card holder, but because you are a self-petitioning spouse of an abusive citizen or legal permanent resident, that unlawful presence is waived for you. So that is one of the many, many benefits when you file for a vow petition as a abused spouse of a green card holder. I hope that clears, that's something that I spoke to someone. I just started consultations this evening. Like I said, I was in divorce proceedings all day. Yeah, you can tell my voice is gone. I had when I had my assistant in court with me today, she goes, "Yeah, your voice is supposed to be gone." And you holler to the point where the judge tells you, "Okay, ladies, the next time anyone makes an objection directing it to any other person, you're going to be found in contempt of court." Yeah, that's what happens. But I just wanted to come on and make this short video. I'm looking at the time because I have a consultation coming up, and just let you know. So please understand, I always say, make sure you get your facts from reliable source. There are a lot of street lawyers. Make sure you get your facts from reliable source. So, hello, Ebony. That's hello, Attorney Ebony. She is hello. Great seeing you on Facebook. That's one of my friends. She's also an immigration lawyer. Also, can you say badass? I think she's also a badass immigration lawyer, and equally loves what she does just as much as I do. Thank you. I appreciate that. Yeah, my voice is gone. Thank you for saying hi. Hi. I hope your day was good. Well, less stress with them now because I've been fighting for everybody all day. But anyway, just to reiterate, yes, you are able to file for your green card while you are in the country, even if your spouse is a green card holder, which, unlike a regular marriage based, where if you're married to a green card holder, you've accrued a lawful presence, you will not be able to adjust your status in the country without your spouse becoming a citizen, and that makes you an immediate relative, or having to file for a waiver of a lawful presence, 601A, get that approved, and then you have to apply for your immigrant visa at the embassy, then re-enter. In a VAWA case, you don't have to deal with any of that. That's one of the great benefits of VAWA. So if we can help you in your VAWA petition or any other immigration services that we provide, VAWA, H-1B, EB-2, asylum, change of status, extension of status, marriage-based green card, employment-based green card, citizenship application, fiance visa, removal of conditions, and few removal proceedings. I don't do all. Yeah. So I know my limitations. If we can help you with any of that, please contact our office. put that. You can send us, contact us through a website as well. That's olalayalawfirm.com. Number again is 334-341-4475. If you haven't subscribed to YouTube, make sure you stop by. I think we finally reached 500 subscribers, which I think for the longest time, like 6-7 months, I had like 8 subscribers, including my fiance and myself. But I guess you talk a whole lot and people are like, yeah. If you haven't followed us on TikTok and Instagram, be sure to stop by Olaleye Immigration. And if we can help you with your case, once again, consultation is $130 for 30 minutes. What we do is if you retain our services within 30 days, no, I take that back. It used to be 30 days, within 15 days. That's when I'm plenty of time to decide if you want to retain our services or not. You will get that credit towards as a courtesy credit towards the total retainer fees. So until next time, Facebook and YouTube, and be sure to share this video. Be sure to invite your friends and family to subscribe to YouTube channel, follow us on Facebook, like our page. I'm everywhere. All right, everybody. Until next time. Bye-bye.